Start. Okay, welcome to the supplementary public hearing for the inquiry into budget estimates 2022-2023. I acknowledge the Gadigal people of the Eora Nation, the traditional custodians on the lands on which we are meeting today, and also pay respects to elders past, present, and celebrate the diversity of Aboriginal peoples and their ongoing cultures and connections to the lands and borders of New South Wales. I also acknowledge and pay my respects to any Aboriginal and Torres Strait Islander people joining us today. I welcome department officials to this hearing. Today, the committee will examine the proposed expenditure for the portfolio of fair trading. Before we commence, I'd like to make some brief comments about the procedure for today's hearing. Today's hearing is being broadcast live via the Parliament's website. The proceedings are also being recorded and a transcript will be placed on the committee's website once it becomes available. In accordance with the broadcasting guidelines, the House has authorised the filming, broadcasting and photography of committee proceedings by representatives of media organisations from any position in the room and by any member of the public from any position in the audience. Any person filming or photographing proceedings must take responsibility for the proper use of that material, and this is detailed in the broadcasting resolution, a copy of which is available from the Secretariat. All witnesses in budget estimates have a right to procedural fairness according to the procedural fairness resolution adopted by the House in 2018. There may be some questions that a witness could only answer if they had more time or with certain documents to hand, and in these circumstances, witnesses are advised they can take a question on notice and provide an answer within 21 days. If witnesses wish to hand up documents, they should do so through the committee staff, and I remind witnesses that they are free to pass notes and refer directly to any advisors seated at the table behind you. And finally, could everyone please turn their mobile phones to silent for the duration of the hearing. All witnesses are sworn prior to giving evidence. I remind a number of witnesses here today, however, you do not need to be sworn as you've been sworn at an earlier budget estimates hearing before this committee. And that just leaves us with Mr. Jim Kelly. You haven't not appeared at an early hearing before this committee, so I just ask that you state your full name, position, title and agency and swear either an oath or affirmation, and the words of both, I think, in front of you.
Thank you, Chair. My name is James Kelly. I go by Jim. I'm Director of Health and Safe Design within the Better Regulation Division, Department of Customer Service. I swear that the evidence now and about to be given by me shall be the truth, the whole truth, and nothing but the truth. So help me God.
Thank you. Today's hearing will be conducted with department witnesses from 9:30am to 11:30am. Now, during this session, there'll be questions from the opposition and crossbench members only, and if required, 15 minutes is allocated at the end of the session for government questions. So we thank you for your attendance today, and we will begin with questions from the opposition, and I think we're going to Mr. Diadam on the screen.
Thank you, Chair, and thank you everyone for your attendance today. Look, I wanted to start with a question about the approach that's taken by Safe Work. Look, I think in a previous inquiry, maybe Ms. McCool might be the best person to answer this, there was a reference made to the underpinning of the Work Health and Safety Act being a risk-based preventative framework. Is that correct, Ms. McCool?
Yes, that's correct.
Yeah, can you just explain to the committee what's meant by that idea of a risk-based preventative framework?
Well, in principles, first of all, we're under model legislation. So that's set out by Safe Work Australia that all states that have adopted follow the same provisions. In terms of risk-based, obviously when we look at matters, we're looking at foreseeability, we're looking at culpability, and essentially going through, from a risk-based perspective, the breaches that can confirm penalties or for action to be taken.
So perhaps you might want to put that sort of in layman's terms. So is it fair to say that a risk-based preventative framework aims to try and prevent accidents from occurring in the workplace rather than focusing on the consequences after the event, after something's happened? Is that fair to say?
Well, of course, prevention is obviously what we're here to do, but we also then have the penalties for where there has been an offence, a breach, an incident or fatality.
So in terms of the compliance work that Safe Work undertakes, the object is really to emphasise preventative measures, to shift the approach that's being taken by employers to ensure that that they are taking necessary preventative measures to avoid workplace accidents. Isn't that right?
That's correct.
That's the direction. That's the, I suppose, the orientation that Safe Work take to its compliance work. It's
Yes.
really aimed at shifting employer behaviour, isn't it?
Well, that's correct. So if you look at any of our deployment schedules, the majority of it will be proactive where it's unannounced. We're focused on the harms that are of most risk, but also, as I said, there to prevent incidents happening. When you look at the reactive work, being our response, our request for services and incidents, that makes up a proportion of our work, but the majority of our work is in the proactive space.
Right, I see. Can you tell me about safety culture? Like, what role does safety culture play in terms of a risk-based preventative framework?
It's very important. The underpinning parts of the legislation is around having a good safety culture, good consultation, safety from the top right through to the bottom. So that basically ties everything in terms of the methodologies of how you do risk assessment. That's done in consultation. The culture of a workplace is very important to achieving good safety outcomes.
So is a poor safety culture a red flag in terms of potential risks? I think if your inspectors are out in workplaces and they can see that there's the absence of a strong safety culture in a workplace, does that indicate a sort of like set off a red flag for Safe Work in terms of its approach to compliance in that workplace?
Well, it is one aspect, but also there's policies, procedures, safe work method statements, consultation, looking at the competency and training of workers. So it is one aspect. It does tie, as I said, a lot of the, I guess, human aspects together. But in terms of, as I said, culture, yeah, definitely is one part. But the other way, as I said, the risk assessments, the consultation, all the policies, procedures, making sure staff are inducted, you're doing toolbox talks, et cetera, is all part of, which also makes up culture as well. So there's also actions that I guess determine how a good workplace looks like.
All those elements would contribute to the to a safety culture in a workplace, wouldn't it? If they're doing all those things, that's indicative that there's a strong safety culture in the workplace.
More or less, yes.
Yes. Okay. Thank you. I might just shift to Miss Mann for a moment. I wanted to ask about the answers to our further supplementary questions. But initially, I just wanted to go to the department's process in relation to responding. So obviously the minister signs off on the responses that are provided to the supplementary questions that are asked arising out of an estimates hearing. But what is the process for the department? How do you go about answering the questions? So, I mean, I've asked, there's been a number of questions around a number of incidents. Does someone go back and review the file in relation to those matters?
That's right. So when the requests come in, we would then allocate them to the appropriate part of Safe Work, and then the appropriate people in that division would review and pull the records as required. Right,
I see. And they'd review the file, and then so the answers would then go through the executive structure. Is that correct?
That's right. So they would usually be signed off by the director, the executive director, and then myself as head of Safe Work New South Wales.
Right. So in terms of the answers, then it's fair to say that those who are here today will have had some role to play in compiling the answers provided to those further supplementary questions. Is that correct?
So not every one of my colleagues will have reviewed every one of the answers, but yes, on the whole, this is the Safe Work leadership team, and on the whole, they would have reviewed different parts of the answers.
Right, I see. And so it's fair to say that in reviewing the answers, you have background information, including, details around the observations that have been discerned from the file. Is that correct?
So as you can appreciate, Mr. Diadam, often these things are compiled with quite short time frames. So if your question is, have we done a full retrospective review of each one of these matters that have been asked for? The answer to that is no. But have we reviewed the information and documents that have been provided? The answer to that is yes.
Okay, thank you. All right, I want to turn to the responses provided to the questions about the Landcom notification around the Lachlan's Line site. They're questions 6 to 11 in the further supplementary questions that were provided, I think, on the 20th of October. Mr. Press, did you review the file in relation to this? This is in your bailiwick, isn't it?
So I reviewed the answers to these questions, but I did not review the incident file, no.
You didn't look at the file?
No, that was done by my team.
So how can you satisfy yourself that the answers are correct?
Because I rely on my team from the investigators through the directors to provide me with the correct information.
So was there a brief behind the answers? Surely there must have been some additional information provided in order for you to satisfy yourself that the answers are correct.
So I have briefs on this matter through other documentation, and based on my review of those, what was provided in response to those supplementary questions, I was comfortable that I could not observe any errors or omissions.
Right, I see. Okay. I wanted to ask about the reason, firstly, the reason why you were asked how many requests for service or notifiable incidents for the site did SafeWork receive in the year before the fatality? And what's been provided is a reference, a table, and they suggest that this is an answer to A and B, and there appears to be 1, 2, 3, 4, 5 specific incidents that are listed there. Do you have the answer in front of you?
I do.
Yeah. So you can see that there's a code for a reference number. Can you tell me what the reference number means?
So that'll be the reference number taken from the WSMS reporting system.
So what does a reference number that begins with a 2 mean?
I couldn't tell you, and have to hand over to Mrs. McCall, who deals with that detail.
It would generally relate to the category. So it's a category 2.
So it's a category. What's a category 2, Ms. McCall?
Category 2 is a serious incident where we respond within 72 hours, and that's an inspector response.
Okay. So so what's listed here is 1, 2, 3, 4, 5 category 2 incidents. The question that was asked was about requests for service and notifiable incidents. So, Mr. Press, was there no request for service?
You'll have to allow me time to look through my files, Mr. Diadam. I only have this.
Okay.
I might get back to you in a couple of minutes if that's okay.
Yeah, that's fine. That's fine. Okay, I might move on. You're aware that at our last hearing, there was some discussion around the interaction between Landcom and one of SafeWorks' senior inspectors. Do you recall that, Mr. Press?
Sorry, Mr. Diadam, I was looking for your answer for your previous question, so if you could just repeat, sorry.
That's okay. I might just give you time to find the answer then.
If you want to continue, we can come back.
The problem is my questions are primarily directed to you, Mr. Press. So I kind of...
If I could say, Mr. Diadam, I think Megan McCall might be well placed to answer some of these questions in terms of background.
Okay. So I believe that there was an answer returned that so at the last hearing, I asked about whether the Landcom notification occasioned a physical inspection on the site.
Yes. Yeah. So we received a request for service on the 1st of December 2017, but it's important to know that at that time, Greenland Developments were the principal contractor. So that was allocated to an inspector Monday, the 4th of December. They attended Wednesday, the 6th of December, and notices were issued on Thursday, the 7th of December. Those notices were complied with and relayed back to Landcom on Wednesday, the 13th of December, with Landcom confirming there were no further issues outstanding and there were no further issues raised by them as well. So from the 1st of December, from notification, the matter was considered closed by the 13th of December. An inspector did attend and notices were issued.
Was that the senior? I know there's been some issue in terms of naming the specific inspector, but was the inspection conducted by that senior inspector who'd been liaising with Landcom?
Yes, that's correct.
So that is the inspector who... They attended site. Why did that inspector then respond to Mr. Betts of Landcom, indicating that it's providing no indication that an inspection had actually occurred? I think he provided a response.
So the inspector did attend the site on Wednesday, the 6th of December. It's also important to note that the incident that occurred 2 years later was not the same principal contractor, and the scaffolding company involved was not engaged at that point in time. So the matter was in relation to Greenland Developments, and 2 years later, when the incident occurred, it was a different principal contractor.
Yes, I appreciate that the contract has changed. I suppose we're looking at the responsiveness of safe work to notifications. And I mean, obviously, yes, the contract has changed, but as you can see from the information that was provided at answer 10, A and B, there was a series of other incidents at that site. So the initial notification from Landcom surely should have triggered a higher level of vigilance from safe work. Is that fair to say?
The issues identified in 2017 related to incomplete barriers, slips, trips and falls and inadequate flooring. It didn't have anything to do with the scaffolding. And at that point in time, the best way to describe it, the project was at the very initial stages. When the incident occurred that you're referring to on the 1st of April 2019, the project was at quite an advanced stage. And as I said, different controller of the project at that point in time. So the information raised was also satisfied by Landcom on the 13th of December, and the matter was closed. And the inspector contacted Landcom to confirm that the issues were resolved.
So there's then a further incident on the 30th of July 2018, isn't there?
1 second.
Malfunctioning concrete hose, I think. Prohibition notice. Improvement notice is issued. So again, I mean, you're out on the site. There's safety issues, and then of course we can see from the answers returned at 10 that there's a sequence of further issues with this site, isn't there?
Well, in relation to July 2018, it related to concrete. From September, it was a crane. November, it went into props, bricklaying, and then, as I said, the incident involving the scaffolding. So in relation to a big site with a number of different PCBUs and different work activities occurring, there was no instances of any scaffolding issues in the lead up. The incidents prior to that related to bricklaying, cranes, and, as I said, concreting.
But isn't, as we touched on earlier around the question of safety culture, like when you go onto a site to do compliance work, isn't it appropriate that the inspector takes into account the overall safety culture rather than looking at, this particular incident, this particular safety breach? Shouldn't you be taking a look at the holistic picture and say, hang on, there's not sufficient vigilance being applied in this site in relation to safety matters. The culture is clearly an issue here that overall presents a hazard. Is that something that the inspectors take into account?
Of course they do, but also in terms of a big site with lots of different contractors, lots of different PCBUs, lots of different trades occurring. As I said, we're generally also looking for common trends, and in this instance, there wasn't any common trend. It wasn't all scaffolding incidents, for example. It was a few different things. In terms of notices were issued in those circumstances to secure compliance. So while they're unique and individual incidents, there was no, connection between them. But of course, we always would look at culture. We'd look at if there's a HSR there, we'd even include the HSR on a walk around. That is our role as a regulator. But there's nothing to indicate here in the information that we have and the matters that we responded to. As I said, there was no instances of notices issued in relation to consultation.
So I suppose, look, where I'm getting at is someone died on this site, as you well know, and there's a number of safety issues that have been identified by the regulator. Isn't it fair to say that your risk-based preventative approach catastrophically failed in this situation?
As I mentioned, the incidents prior to the lead up to the scaffolding collapse didn't provide an insight that was foreseeable. The PCBUs at that time, as I said, were managing controls. There were no incidents in relation to scaffolding. It was a tragic incident that obviously we take very seriously, and including the work we've done with the families. But in relation to making that, allegation, there's no information that would support that, as I said, that we could foresee that there was going to be that scaffolding collapse 2 years after the Lancome matter or in the incidents prior.
Wasn't there an incident on the 22nd of the 1st, 2019, where a bricklayer fell from a scaffold as a result of the scaffold not being properly secured?
There was a spreader bar that had been removed, but that's not indicating that the scaffolding wasn't erected. It was a worker had removed a component.
Isn't there something wrong with the compliance approach that's being taken by Safe Work if you're focusing on the specific incidents rather than looking at the whole safety environment at a site?
We do do a full site inspection. So in terms of while we're looking at the incident, we do look at other things there. So there's, again, in the information we have, there's no information to suggest that we weren't doing full inspections or looking at other things than what the incident related. So when we go there, we will check other things. We'll check housekeeping, we'll check who's the HSR, we'll check their records, we'll check various things. So in terms of it's not an out and back situation when we go to site.
Sorry, Mr. Yeo, I'm going to stop you there. I'd let you go with a couple of questions.
I was waiting for you. I was at 21 and I thought, what's happening?
Yeah,
okay,
no worries. We'll come back to you in about 20 minutes. Just for my line of questioning, I was going to hand up some documents and for your reference there from a Freedom of Information request, put by some concerned residents at Cooma regarding the reservoir explosion which occurred on the 4th of the 1st in 2020. Once you get them, I might just
Thank you.
get you to turn to the fourth page, which is essentially the summary of events. So if you look at the couple of paragraphs there describing the event, is it safe to assume that that information was obtained by Safe Work New South Wales by talking solely to council about the incident? Like, how was that information obtained?
Mr. Benassiat, this sits in my area, but I wasn't in Safe Work at the time this arrived, and I don't know specifically how this was gathered, but I do know that information on the incident was gathered from a range of sources, not just council, any particular one person.
Okay, so if we go down the page, specifically where it says the tank was constructed in 1958 and it was last inspected by Public Works in 2014 after some leak repairs, who would have given you that information?
Yeah, so I
We
can
can,
answer it.
well, we can all presume how information came in, and we presume it might have been council officers.
Okay. But we're not certain that it was from council. Because my concern, well, the fact of the matter is that one sentence there is false.
Thank you.
Particularly where it says that it was last inspected by Public Works in 2014. The last inspection was actually in 2018 after it was decommissioned in 2017. So my concern is whoever provided you with that information provided false and misleading information regarding the safety of this water reservoir. So if it was council, that's a concern. If it was someone else, that's a concern. I'm trying to ascertain who actually provided you this false and misleading information, which then obviously led to a poor decision around this incident.
Well, I'm not sure from my perspective whether that particular information is determinative in how this matter was handled. Thank you.
Right. Is there anyone on the panel that can tell me who gave you this information? Because my concern is that this was considered a Category 2 incident because of risk to life, and then Safe Work New South Wales, despite not receiving any investigative report or any maintenance records from council, decided after 14 days that you didn't need to investigate any further. And we now find that what they did provide you was false and misleading, or what information you do have was actually false.
So the information I have is that I described the process a bit differently, so that there was quite a significant review of the matter, actually by 2 inspectors. And I've gone through the report that was provided by the second inspector, particularly to the investigations decision-making panel. That report is very comprehensive on the issues with the tank. I would say it was known that the tank had issues. It needed repairs. The IDMP report, for example, reports to the fact that council had discussed that it needed significant repairs in the region of $900,000. So that information about the state of the tank was known and considered.
When did Safe Work decide to actually implement that IDMP?
So that was on the 11th of August 2021.
Right, but my concern is that Safe Work New South Wales decided after only 14 days of that incident back in 2020 that there was nothing to see here, move on. So a year later, you decide that there's something worth looking at. So when did Safe Work New South Wales become aware that there was a second inspection by Public Works in 2018? When did Safe Work become aware of that document? Was that during the investigation decision-making panels? Wrong?
I don't have that information.
Does
I don't know
anyone
this.
have that information, or do you want to take it on notice as to when Safe Work found out about the 2018 Public Works inspection?
I can give a general timeline. So the incident occurred the 4th of January 2020, as you know. It was notified by the police on the 5th of January 2020. A bigger inspector attended on the 9th of January, and it was closed out locally on the 14th of January. It was later in July 2021 when a member of the Community Advocates Association contacted Safe Work, and the matter was reopened. It was triaged also for another inspector response, and also the matter was investigated by the manager from the South Coast that's responsible for Cooma, and that's where the IDMP submission was raised. The committee didn't support a decision for further investigation, and the matter was closed.
Okay, so in that timeline, when did the 2018 Public Works report come to light?
Through the course of that, raising it to the investigation decision-making panel.
Okay, and did you go back to council and ask why they provided that false and misleading information
I couldn't
when they only referenced the 2014 report? Because the 2018 report is significantly different.
I have no information to indicate it was false information. We'd have to look into that.
Well, clearly it is false, isn't it? Because, you know, you've got your file here saying that Public Works did an inspection 2014 and that was the last inspection, but we now, as part of these documents, you have a 2018 inspection, which lists quite a whole heap of things that need to be done to this reservoir as critical, you know, extremely critical. So, you know, which says address without delay, notify operator, warn personnel in the area. You know, and the risk of that is catastrophic if you don't do those things. And that was in 2018 that council knew about this, and then council then decides to fill up a water reservoir. Mind you, they didn't need to, because RFS warned them they didn't actually need to fill that reservoir for firefighting capability, but they ignored that advice. And clearly they ignored a Public Works document that said that they shouldn't be using this reservoir unless those things were done. So I think the community, and I think this committee should be rightly concerned that, you know, someone's provided you with false and misleading information, and perhaps due diligence wasn't applied by your office in investigating this matter, because you closed it within the first 14 days, but then when you reopened it, you saw nothing wrong. Were you aware of the 2018 Public Works document when you did that panel?
Mr. Banasiak, if you do have further information about council somehow misleading Safe Work New South Wales, I'd be very keen to obtain that, and we can.
Well, it's there in front of you.
So,
you've got information there that says that the last inspection was by Public Works was in 2014, but then you've got a Public Works document dated 2018. So,
how could you not know about that?
like, clearly the evidence is there right in front of you. Someone's given you wrong information, or you haven't done due diligence and checked that information is correct. It's for me, it's one or the other.
So we'll have to take this particular incident on notice. But as I said, if you do have any further information, we'd be very welcome for it.
We also know that this matter has been reviewed by ICAC because I referred a referral recently where they received information where a complainant suggested that council had provided misleading information. Their view, they'd reviewed that and decided not to investigate it and reviewed it back us for further consideration. So they may well have already looked into this themselves.
Did any member of Parliament or did the Minister raise concerns about this, either at the time of the incident or in and around the time that you decided to go to this decision-making panel?
Not to my knowledge, no. certainly that would not be acceptable practice. So no.
All right. Well, I guess that's all I have for you at the
I
moment.
think, Mr. Benasiat, this incident is clearly a really challenging one. I think the IDMP had a really complex case to try and look at. From my knowledge, the issues with the tank and its failings were well understood, but the decision-making panel waived heavily on the fact of the scenario that it being through bushfires, times of stress, and also considering the outcome there that there was no known serious injuries or anything of that nature. Now, I'm not here to say that was necessarily the right decision, but that was the context that they looked at this, and that's the decision they made. I have no powers now to re-investigate that. It's now statute barred, unfortunately, but it's not necessarily the decision that I would have made at the time.
Well, I think the fact that there was no injuries or no deaths is probably good luck rather than good management. Like there was a 85-year-old or 90-year-old woman that was blind and woke up in the middle of the morning floating in her bedroom. So, and there's also concerns around the disposal of household waste wasn't done according to proper guidelines in terms of getting rid of asbestos. Did that come up during your investigation in the independent decision-making panel in terms of the improper disposal of asbestos? No?
I can't recall, sorry.
Do you have any information on your laptop there about that?
I'd have to go back into the submission to confirm that for you.
Okay. Is there any of that, any of those documents regarding the investigation decision-making panel's decision or investigation that you'd be able to share with the committee on notice? Obviously,
I'd be happy to.
Might be able to seek some advice and get that to us.
Yes.
That would be great. I think that concludes me. So I might throw back to Mr. Primrose.
Good morning, Ms. Mann. I apologise for my voice. I've got a bit of a hay fever going on here. Can I just get clear from what was just said in relation to the IDMP? Is it the policy position of Safe Work that you don't investigate a serious breach that could have caused catastrophic injury because there were no injuries?
No, so Mr. Primrose, perhaps it would be helpful for the committee for me to talk to you about how the process
Well, it'd
works.
be helpful for me if you just tell me whether that's the case or not.
So first of all, what will happen is the inspector is empowered under the legislation to have autonomy and independence in terms of what action they take when they're investigating a matter. So it's the inspector who must form the reasonable belief whether or not to issue those prohibition notices, and they do that in complete independence, and that's their role. As a matter of good practice, as a regulator, and I've been a regulator now for almost 20 years, when we determine whether or not to take something to prosecution, it isn't left to one inspector. And so what we have in Safe Work is we've set up a robust and rigorous process called the
I'm
IDMP.
sorry, can I just stop you there? What I'm trying to understand
is a peer
is
review.
what's been put to us in relation by the chair is that firstly, even though a report was referred by Peter Anderson to the IDMP, that 2018 report, you've indicated that no further action was required because, there were no serious injuries, whereas I understand that risk is the focus of a Category 2 investigation, not injury.
You're absolutely right, and perhaps if it would help, I can tell you the considerations that the IDMP makes when it's determining whether or not to send a matter to prosecution. So the first consideration is the severity and scale of potential actual harm. The panel then looks at the seriousness of any potential breach of law. It then looks at the duty holder's compliance history. It looks at matters of significant community concern or emerging issues. It obviously looks at evidentiary matters, so the availability of reliable evidence to proceed to investigation.
You didn't even have the 2018 report.
To jurisdiction and to the public interest. So as you can imagine, it's a very complex matter. We have our Safe Work senior leadership team reviewing those matters. It's not easy. And do I agree with all of the decisions of the IDMP when I read them? No, I don't. But there is, in terms of a mechanism, it is very important to have peer review for consistency and transparency. And I think if I could just make one more point, Mr. Primrose, you will have seen that we are now holding an investigation, an inquiry into Safe Work New South Wales. Mr. McDougall will be conducting that inquiry, and these are exactly the sorts of things that I'm going to ask him to look at to make sure that this panel is still fit for purpose and the considerations that they're applying are appropriate.
Yes, I noticed that so far your agency is currently being investigated by the New South Wales Auditor General, a 6-month inquiry, amid allegations that you failed to protect workers from serious injuries and death, and its inspectors were subject to political interference. And then, as you've just mentioned, your minister's announced that he's appointed retired Supreme Court Judge Robert McDougall to carry out a review of Safe Work. As of 10/10, are you aware of any other inquiries into Safe Work that are about to be conducted?
So
We only got 2 major inquiries
if I
so
could,
far.
if I could, please. So I've been in this role now for 11 months, and I want to say that the people of Safe Work are incredible. The inspectors and the management team are incredible. They genuinely take their job very seriously. They go to work to make sure that workers come home safely. However, it is time to have a look and see how we can do better. And some of the matters that we've raised today are exactly the sort of matters that we want Mr. McDougall to look into. So I very much welcome the McDougall review. I've spoken to Minister Dominello in the lead up to that announcement, and I very much welcome and encourage it.
Yes, can
terms
I
of the
make
Audit
it clear? I
Office
don't think
review-
anyone's criticising the inspectors. You're the guys in charge, as is the minister. And I note that you've, in the ministerial release, you've expressed your support for the independent review. Which are the particular problem areas that you'd like it to zero in on, where you don't believe you've been performing up to standards so far?
So as I said, the Safe Work inspectors, the management team, it's a really difficult job, and we've talked about 2 of these matters today, but we get 20,000 matters notified to us each year, and many of them have features of serious injury and fatality. This is not an easy job for anybody.
No, look, we all fully appreciate that, but I'm trying to work out, given you've just given me a reason you may have problems, so what are you hoping that these 2 inquiries will target to improve your performance?
So if I turn to the Auditor General's review, first of all, it's not a sort of an investigation as you portray it. What it is we have been added to the 2023 Auditor General's program of works, of which there are a number of agencies and programs on that list, that 2023 list. So I think it was unfairly characterised in the media as some sort of investigation. We're added to the program, and we very much welcome audit reviews, and they're part and parcel of government. So that's the first thing, and the Auditor General will look at performance. So she'll look at things like timing, requests for service. Have we responded within our timeframes? Are our timeframes accurate and appropriate? What is the governance of processes, and is that appropriate? So she'll look at the performance level. When I've spoken to Mr. McDougall, I think what we're looking at is to make sure that he doesn't overlap with that and that the 2 reviews complement one another. Mr. McDougall will be looking more at sort of the culture and the functions that we do, and are we doing them properly?
Yeah, tell me though, what
wide-ranging.
particular things do you want? Which are the problems at the moment? You've already outlined that you're getting a lot of referrals, a lot of concerns being expressed, and I'll move on to some of the things your own staff are saying in a few minutes. But can you tell me which things are causing you concern at the moment that are leading to the problems that we've already seen and heard of this morning in relation to Cooma?
So as a regulator, any regulator, we can always do better. And some of the decisions and actions that we've taken, I think on any view, we could have done better on them. So what I'm hopeful for is that the 2 reviews will help us do better as a regulator. We're never, unfortunately, going to stop PCBU's stop their serious injuries and fatalities occurring altogether. But I would like to see some of those numbers going down and see PCBUs do a better job of protecting their workers.
Okay. Do we know yet what the terms of reference for the McDougall review will be?
So I've been speaking to Mr McDougall about that, and we're in the process of settling them. And as soon as they become available, Mr Primrose, I will send them to you, but they'll be publicly available.
Yes. When do you expect them to be announced?
So I would expect them. We'll probably work through them in the next week, and I would expect them the following week. But obviously, I want to make sure that Mr McDougall is happy, and also that the audit office doesn't feel that there's duplication. Do you expect that there will be submissions? Absolutely, there will be submissions.
When do you expect that they may close?
I'm afraid I don't have those details. As I said, I've been working with Mr McDougall, and we will have those timeframes shortly. But I would anticipate that he will run it in the same way as he ran his review into CIRA and iCare. So there were interviews, there were submissions, and the report and the submissions were made public where they were permitted to be made public.
Do you expect there will be open public hearings?
So again, I will be speaking to Mr McDougall about whether he thinks that is a good way for him to proceed with the inquiry. So I can't answer that question at this point.
Would you hope that there would be public hearings?
So I know that the CIRA and iCare inquiry that he conducted did not have public inquiries. He may feel that garnering evidence in private is a more effective way of doing it. But again, that's a matter for Mr McDougall, and I obviously will respect what he wishes to do.
Okay. Can I just now turn to some issues regarding workplace culture? And I noticed that in the further supplementary questions, there was a request for 5 years of Safe Work New South Wales People Matter Employee Survey, PMES, were asked for. In the answers you provided, 2018 and 2019, but 2017, 2020 and 2021 were part of the parent cluster results. Are you able to provide that for those years?
I believe we have provided that in the additional supplementaries, but if that's not the case, then I can certainly provide what we have. To clarify though, there have been structural changes along the course of those years, which can provide some impediments. So for example, the 2017 report that we provided, that is a combination of Safe Work and CIRA data, because at that time that's how the organisation was configured. So there are some limitations, but we'll absolutely do our best. And I should say, I think the PMES results, well, I don't think, I know they are very strong, and some of the allegations that have been aired publicly have caused this senior leadership Safe Work team to really interrogate the PMES results. And Mr Primrose, they are strong. So, for example, we have a 71% engagement rate, which is 7% higher than the public service average. And some of the things around bullying and misconduct, our rates are very, very much lower than the rest of the sector. So that's the difficulty for me. I'm hearing things, and it sounds like you have some comments from people, but the data that we have in front of us and what we're seeing isn't necessarily reflecting that. In fact, we're beneath the average, the public sector average, in terms of those bullying and harassment numbers.
Okay, let's look at compliance and dispute resolution for 2021. 8% of respondents had the intention to stay for less than 1 year in the organisation.
So,
20% witnessed to experience bullying, 9% experienced discrimination.
So can I just add some colour to the people wanting to or intending to leave? I looked at these figures last night, and I think they are really important for this committee to understand. So in the inspectorate, or the CDR area that Mr Press runs, our Safe Work inspectors, it's an ageing population. The demographics are that 100 of our current inspectors are 56 years or older, and 21 of those inspectors are over the age of 65. So we're actually expecting, and people are expecting to retire shortly. So we have a workforce issue that we're looking at workforce strategies to manage. But that might explain that figure.
Well, let's have a look then also at WHS Metro 2021 results. 70% did not say grievance handling is favourable. 70% did not say recruitment processes were favourable. 53% did not agree that their organisation meets the needs of communities, people or businesses of New South Wales. And that was higher than the cluster by 35%. How do you respond to that?
The cluster by 35%, is that?
I don't know. Before it predates.
Is this which year is this, Mr. Primrose?
2021.
2021. Sorry, I don't think we're able to have a look at those figures because I don't have them.
I would hope you'd have them.
Mr. Press.
I would.
We're having a look and we might be able to explain.
But I do know so the last reporting period, WHS Metro, was 56% engagement overall. And they've had, there's some good reasons why their engagement might be lower, particularly in the current period, because they're going through just a restructure to try and help solve some of these issues with how we manage staff and how we ensure that we've got enough people in these manager roles going forward, particularly with our ageing workforce.
Okay. Well, let's look at one unit in particular, health and safe design. Okay. Grievance handling. 59% did not say it's favourable. I can keep my work stress at an acceptable level. 34% did not say yes, higher than 2020 by 12%, higher than the cluster by 5%. I have the time to do my job well. 47% did not say yes, higher than 2020 by 22%, higher than the cluster by 18%, higher than the parent by 12%. Now, the key takeaways, very bad stats across the board. Grievance handling, unfavourable, 70%. Action on survey results, unfavourable, 77%. Organisation does not meet the needs of the community or recruitment decisions. Sounds like a bit of a basket case to me. How do you respond to that? Or aren't you aware of that one either?
So I think a basket case is unfair to the people in that.
No, it's not. I'm not talking about the people there. I'm talking about the managers.
So
well, if we look at health and safety design this year, they've got 73% in employee engagement and, a lot of areas which are in the high 60s and 70s. So
they've gone up.
So you can refer to the previous period. I guess I'm more familiar with the current period, and in the current period, things are heading in the right direction. There's definitely room for improvement, 100%. But today we have quite a different landscape to those previous
So you'll
years.
table that document you've got there you're reading from at the moment?
Most definitely.
Absolutely.
Okay, table that and we'll do some comparisons, because that's certainly not what your 2021 New South Wales Public Sector Employees Survey, People Matter, has reported, which is the most recent available to us.
So I did table to the committee earlier in the week our 2022 PMES results, and they've just only come through to us, which is why we tabled them, and I thought that would be instructive, but we can absolutely table the lower by unit rather than as aggregated as better regulation.
Okay, well, that's me on those ones. I might hand back to Anthony in the time available.
Yeah,
Okay,
Mr.
thank
Diadam.
you. Thank you. I might first return to Mr. Press and the question that was left awaiting his response on the issue of notifiable incidents with requests for service for that Lachlan Lines. So is there a reason, Mr. Press, why there was no answers in relation to the request for service?
I think in fairness to Mr. Press, he's been answering other questions and perhaps might not have the information. Mr. Diadam.
I haven't been able to get the information in the time, Mr. Diadam. I'm sorry.
All right, I might come back to then Ms. McCall. Just referring to the answers in the table at answer 10 on the further supplementary questions. So I wanted to ask about this incident on the 22nd of the 1st, 2019. This is the incident of bricklayer falling from scaffold. I'm getting a bit of an echo. I'm not sure whether that's the case in the hearing room.
No, we're all right.
No? Okay.
Must have surround sound.
So, Mr. McCall, the advice is that there was an improvement notice issued and I think a section 171 notice to produce documents was also. What documents did you ask for?
I would have to request a file, but in terms of all notices were complied. So the documents they were asked to, they did provide, but I don't have those documents in front of me.
In terms of those, there appears to be quite a few in the list of these section 171 notices being issued. What's the underlying purpose of the request for documentation?
Oh, we're always
does that do?
looking for safe work method statements. We're looking for evidence of training. We're looking at evidence of toolbox talks. We're looking for anything that relates to the workers, whether they were trained, they knew how to work, they understood the requirements in terms of the risk. So we're always looking for documents, as I said, to support that all the duties of the PCBU were followed or not. So we will request anything in relation to beginning to end for that work task.
So you can tick the box off to say that the workers have been trained, the relevant information's been provided, and the safe systems are in place.
That's
one
one
aspect. The purpose of it?
That's one aspect, but we also talk to the PCBU, we talk to the workers. So there's a lot more that goes on, but in relation to, we need to see the documentation as well. So you'll find in most matters, we're also looking for the documentation to support what they're saying. And that workers have
So I
signed
want to come
on.
back to this question around I suppose it seems that there's been a number of safety incidents at this site. There's been incident-specific responses. The regulator was aware that there have been safety issues on the site. Fatality still occurs. Surely that indicates that there's something wrong with the compliance approach that's being taken by Safe Work.
Well, as I said, the incidents, there is no, I guess, line of sight that the incident that occurred on the 1st of April was foreseeable based on the matters that had been looked at prior to that and the inspections done prior to that, the request for service. So in relation to our understanding of that site, there was no way to foresee that on the 1st of April that would happen.
Is it a case that you're addressing the symptoms without actually looking at some of the root causes that might lead to a situation where a fatality occurs?
Not necessarily. We also do risk-based investigations. So sometimes where no one's injured, but we're consistently seeing a trend of repeated behaviour, we can also run an investigation without even an incident even occurring. So in terms of if we do see that line up, which you commonly refer to as the Swiss cheese model, you can see that a pattern of behaviours or a pattern of incidents. But in this particular matter, at this site, there wasn't a patterning of the same behaviours or the same incidents. As you can see, there was one with a crane, there was one with a bricklayer, there was one with the concrete. There wasn't a run of scaffolding incidents to suggest that was going to happen. And also in relation to going back to that, we also do fast-track investigations where we'll list things in the local court as well. So in terms of, as I said, we have all those tools available. They're within, particularly in risk-based, and we also investigate things where no one's been injured as well.
So it's your evidence that in this situation, nothing that Safe Work could have done could have prevented that fatality from occurring?
Well, PCBUs are responsible for controlling the site and ensuring that all workers are working safely. In terms of our role is to check that that is actually occurring. So the principal duty relies on the principal contractor, and the matters leading up and the visits leading up, as I said, was not foreseeable that that incident would have occurred on the 1st of April.
Let's see.
So, Mr. Adam,
Can I turn to the-
look into your question
Oh,
for
yeah,
you, if I
Mr.
could
Press.
interrupt, sorry, because I know you've been waiting for it for quite some time. So, your question was about the number of requests for service in the year before that incident. And so the response to that question is provided in the notes. That's not to say that there wasn't further requests for service outside of that reporting period, but in that 12-month period, that's the response.
That's it. So every request for service was a category 2.
Is my understanding, yes.
Right. Okay. Thank you. Ms. McCool, I might come back to you again and draw you to the answers in relation to question 12 around the fatality at Aussie Skips. Now, there were a number of requests for service at this site prior to the fatality occurring. You can see that, can't you, in the answer?
Yes, I wasn't involved in that area, but I have been briefed on the matter.
So there was a request for service on the 4th of May, and that occasioned a visit on the 24th of May. So that was the date that the fatality actually occurred, isn't it?
Yes, so there was an anonymous complaint on the 23rd of April raising concerns about traffic management, and the inspector attended the following day on the 24th, and that's when the fatal incident occurred.
And so is it the case that the fatality occurred at the time the inspector was there?
That's my understanding.
So even though the regulator was on site, he wasn't able to prevent a fatality from occurring.
That's correct.
What does that say about the effectiveness of safe work as a regulator? Even when there's an inspector on site, the safety conditions are so poor that someone is killed.
This matter, as I said, on review, as I said, I wasn't involved in it, but on review, as I said, does concern me. It's one of the matters, as I said, that I, particularly noting the families involved, it concerns me.
Is it not a similar situation where you've had repeated requests for service, sort of limited response from safe work, and when you finally get out there, it's too late?
Mr. Adam, I'd like to answer this. So I think this is absolutely, these two examples and others is something that we'd like Mr. McDougall to look at. I think as a regulator, just as you're saying, we definitely have to try and spot the patterns and lift ourselves up. You can see from each of these incidents there has been responses, and the responses on their merits are proportionate. So there's the issuing of notices, those notices are followed through, there's prohibition orders and so forth. But it's what can we do differently to actually get a behavioural change? And that's probably the missing piece here, that there's been responses, most definitely site visits as well, but we haven't secured the behavioural change, and that's what's most important.
Yeah, the stuff that changes safety culture. Isn't that the case, Mr.
Well, not just
Press?
culture, practice. You know, it's the execution that matters, right? Culture's very important as well, but we want to actually see it applied and implemented daily.
Yes, if it's embedded in the culture, then obviously everyone on the site is applying vigilance when it comes to safety. Isn't that right?
Culture, policies, procedures, collectively.
Is it perhaps the case, Mr. Press, that in both of these situations, both at Lachlan's Line and this Aussie Skip site, that the employer or the PCBU was not concerned enough about the consequences of failures in their safety systems that they weren't proactive in terms of improving the safety situation in the workplace.
Look, I don't have a
And
crystal ball, so I really couldn't hypothesise on what those individuals were thinking. But like I said, from a regulator perspective, it's about trying to make sure that we don't have repeated interactions, regardless of whether they're for different issues, and we get that culture change, that behavioural change there. So I'm not sure what the gap was here, and again, that's a perfect example for Mr. McDougall to look into to see what we could change in our approach to try and secure a better outcome.
Do you think that the fact that there's light touch compliance approach is contributing to this indifference on the part of PCBUs in unsafe workplaces?
I don't think there is a light touch approach to compliance. And again, this is a 2018 incident, so there's completely different people throughout the organisation at the inspector level, manager level, all the way through. So I'm just still getting a grip about current approaches, but I definitely don't think that there's a light touch approach today.
So there's been an uptick, has there, in terms of penalty notices being issued, or?
I don't think that's a gauge
Since
about
2018?
our effectiveness, number of notices being issued. That's always in response to the behaviours we see. But I can definitely see from the number of proactive visits that that's consistently high, and we are getting out there on projects just as much as we were, if not more so.
Can I ask about actually, I might just get to the question of the IDMP. Who sits on the IDMP?
The IDMP has all of our safe work director leadership team. So there's 7 of them that sit on the IDMP, of which.
So who are they, Ms. Mann?
Oh, sorry. Yes, it's Ms. Mann. So there's 7 directors, 7 safe work directors who sit on the IDMP currently. And the process is that the inspector who has gone and done the investigation will then, the inspectors will prepare a brief for that, and that brief will be put to the IDMP in terms of whether or not the matter should go to prosecution, and a decision is made, and it's a majority decision. And my understanding is that there's often different views around the table. There's robust discussion. So it's a very, in terms of a regulatory process, it's a very important assurance and governance process.
So in terms of the directors, what qualifications? The only qualification is that they're in the leadership of the organisation.
So we have 2 of the directors sitting with us today. One is Ms. McCool and one is Mr. Kelly, who are eminently qualified. And I don't know whether you wanted to talk about your qualifications at this hearing, but they are qualified, experienced directors.
Are all of them qualified?
Well, it depends what you refer to as qualified, but I have full confidence in all of them, and many of them have been in the organisation for a very long time.
But all of the positions, so it's a role that's conferred by virtue of them holding the director position. There's no specific requirement or specific qualifications to sit on this panel.
No, so I suppose the concept of it is that rather than the person or persons with carriage of the matter determining that it ought to go to prosecution, it goes to a panel of directors across the safe work business who bring different lenses and different perspectives. So it's a form of peer review. Now, Mr. Diadam, I should say that a few weeks ago I have asked for a review of the internal decision-making panel. It was established, I think, in sort of the 2010. It was independently reviewed in 2014. There have been some changes to it as a result of certain things since that time, but I have asked for another review to be undertaken just to make sure that membership is fit for purpose, chair is fit for purpose, and the process is fit for purpose. But it is an important mechanism, and I wouldn't want to get rid of it altogether. It's a good feature of strong regulatory practice. And as I said, I've been a regulator in other environments for many years, and it's a very strong feature of good regulatory practice to have this peer review panel. I think
so. Effectively, it's the management of the organisation acting collectively. Is that a fair characterisation?
It is the Safe Work leadership team looking at whether or not a matter ought to proceed to full prosecution, applying transparent and agreed principles based on best practice.
Are you able to provide on notice how many referrals have been considered by the IDMP for each year for the past 5 years?
I can provide since the 1st of January 2020. Would you like that now?
2020.
1st of January, since the 1st
Yes,
of January 2020. So there were 355 matters taken to the panel. Out of that 355, 158 were recommended by the inspectors for full investigation. And
So can I just clarify, when we say full investigation, that's not an appropriate term. It's a shorthand term. It's the matter's already been investigated, and often a great number of compliance actions have been taken. This is really about whether or not we proceed to go further with a view to prosecuting. Sorry, Ms. McCall.
That's okay. So in terms of matters with intent to prosecute, 355 were reviewed. 158 were recommended by the inspectors to proceed, and 197 were recommended for no further action by the inspectors.
And what was the outcome?
Yep, out of that. So out of the 158 that were recommended to proceed, 26 of those were not supported, with the rest supported. But equally, on the flip side, where the inspectors recommended 197 be closed, they were overturned by the panel, and 19 were reinstated and went further.
Right. And that's over.
From
What's that? That's one and a bit years. Is that right?
Yes.
1st of January 2020.
2020.
To what's the end date for those statistics?
That was this month.
Nearly 3 years.
Up to this month.
Yep.
October.
So it's nearly 3 years of data.
Right. Okay. Thank you. I might hand to my colleague, Mr. Primrose, for a moment.
Yes, thank you. Can I just clarify, Ms. Mann, can you tell me who's conducting the IDMP review that you mentioned?
Yes, so I commissioned that review to be done by our policy and legislation team initially, but I have in mind that they will do the prep work, and then obviously the matter will be considered and it will be further reviewed by Mr. McDougall and the Auditor General. But I wanted to get started on it now and gather all the information together so that we've done, we've kicked off the process.
So that will be specifically included in the terms of reference, you hope?
I don't know whether it will be called out in the terms of reference. It may well be, and it's certainly something that I would like both reviewers to look at.
Okay. Who's actually determining the terms of reference for the McDougall review?
So ultimately it will be something that Mr. McDougall and I will look at. We will get ministerial approval and government approval for it, for the terms.
So it'll be a matter for Cabinet?
I'm not sure whether the terms of reference will need to go back to Cabinet, but they will certainly need to get Minister Dominello's approval.
So in addition to yourself, who else is being consulted?
Consulted on...
In relation to the terms of reference?
So they are being developed. Mr. McDougall, as you know, he conducted the review into CIRA and iCare, and during that heard some matters around safe work. So I think he has a fairly clear idea of what needs to be done. But the other person is Margaret Crawford, the Auditor General, because as I mentioned earlier, we want to make sure that the two reviews work, complement one another rather than duplicate.
I'm just trying to get an idea who else is having some input into what should be considered in the terms of reference.
So the terms of reference will be broad ranging, and I'm sure that it can capture a lot of the matters that we've talked about. But as all terms of reference, they're usually determined. There's not usually a public consultation process on what the terms of reference will be, if that's what you're suggesting. I think we just want to get going. We want to get ahead of it. The Auditor General report is not kicking off until next year, February, thereabouts, and we really want to get Mr. McDougall started so that we can make some progress in this year.
So I would guess the other concern, though, is you would actually want it to be comprehensive and right as well as fast.
Absolutely, and the terms of reference will be broad, just as they were for CIRA and iCare. They will be all-encompassing, I would suggest.
Okay, it sounds as though you've got a pretty good idea what might be in the terms of reference.
Not as yet. So we will be doing that next week. But I do certainly, as you've seen today, I have some matters on my mind that I absolutely would like him to look into.
So there's no suggestion that there might be an outsider, another group, a lobby group, etc., having some input into what the terms of reference might be?
No, absolutely not.
Okay. I just have this image of, turkeys not wanting to advocate for Christmas. I'm just wondering, in terms of someone reviewing your agency, you don't want to open yourselves up to people who have specifically discouraged particular matters being considered.
As the head of Safe Work New South Wales, I want this review to be as comprehensive as possible. I want there to be forensic review of matters that have been dealt with, that could have been dealt with better, of the culture, of the way that we conduct our proactive and reactive compliance. I want it to be all-encompassing. As I've said, I've been here for 11 months now, and I want our regulator to be the best, the most trusted and customer-centric regulator that there is, and that's my imperative.
Good. I'm sure we all want the same thing, which
Absolutely.
is why we always encourage maximum consultation in relation to matters.
And you will have that through the process. I'm sure Mr. McDougall will make sure of that.
I look forward to seeing the terms of reference.
Yeah, absolutely.
And then seeing you at estimates next year. Okay.
I'm looking forward to that too, Mr. Primrose.
Okay, thank you. Can I ask how many inspectors there currently are in
Yes.
SafeWork?
There are 370 inspector roles, and that number went up. It was previously 331 inspector roles, but there was a $6.4 million budget investment in the 2021 budget, which gave us 39 new roles. So there's 370 roles in total.
Okay, so how many new inspectors were recruited in the last 12 months?
I don't have the recruitment figures on me, but I do have the current numbers, if that would help. So before I move to the numbers, I should say that the 370 now lifts the ratio to one inspector for every 10,000 workers, and that's in line with the UN's ILO benchmark. In terms of the 370 roles, currently, the most current data that I have is that 336 of those are filled, and there's a vacancy of 34. So that's a vacancy rate of 9%. And just to give you an indication, by comparison, our department, the Department of Customer Service, carries a vacancy rate of 14%. So our vacancy rate is actually 5% below the department that we sit with.
Okay. And all of those new inspectors were completed their training in full before they were given their authority to act?
No, that's not the case. They don't complete their... So we trying to respond to the challenges we have with recruitment.
I can't hear you.
Oh, sorry. Trying to respond to the challenges we have with recruitment, we invested in a fast-track process recently in the last 12 months where we have on-the-job training and authorisations given progressively so that we don't have to wait for the full completion of that 12-month program before we can have people active in the field. So they effectively do training on certain competencies and then authorised to do that work, and they build up their skill set progressively.
So they're given their authority before they've completed their training?
No, they're given their authorities in line with the training that they've completed. So it's in a piecemeal approach rather than sort of waiting very much to the end.
So they don't require another inspector, for example, to accompany them?
So they are mentored through the job, and the tasks that they can undertake align with the stage of training that they're up to under that fast track process.
Sorry, they've got their authority.
Well, they might have partial authority. So
But they still require someone to accompany them
correct.
when they go out. How does that work?
I'm not sure what.
I mean, I'm trying to get an understanding of, are people trained and authorised to act, or are they still undergoing their training?
They're still undergoing their training program. This approach gets that 12 months training down to closer to 6 to 9, and so we understand, because they're still going through the program and they're still inexperienced. We have that support and chaperoning, as you say, throughout that process, which is, I think, totally appropriate.
Okay, and that's a satisfactory process in your view?
I think it's a significant improvement from the previous process, where we had effectively people unable to offer any inspectorate services until they'd finished that 12 months. So it's not necessarily the end of the game there, but I think that's a significant improvement on what's happened historically.
Have you had a recruitment drive in relation to former inspectors or retired inspectors?
I wouldn't say we've had a recruitment drive, but we have in recent times had some inspectors who have retired and they've been able to come back for a period of time just to help us get through gaps, knowing how challenging it can be to replace them.
How many?
How many have had that return to
How
work
many have come
process?
back and for how long?
I guess there's two things. There's whether they retired and came back, or those that left the organisation, went back to industry and then decided to come back to the regulator. So I guess there's those two scenarios. I don't have the ones on retirements, but just in my area, we've had one returning inspector where they went to back to industry for a couple of years and then reapplied and started the process again.
Could you take the other matter then on notice, if you would? Thank you.
I think that approach has been a really good way of trying to make sure that I think that approach has been quite good for the organisation, to be honest. It's to make sure we don't lose all of that capability and experience, and giving us more time to, yes, send them off to retirement, which is what they want to do, but, get a bit more mentoring experience and capability building back through the chain.
Okay. I'd just like to ask two questions, if I can, in relation to matters relating to bullying. How much has SafeWorks spent on legal costs for IRC matters, including bullying, so far in 2022?
So we've had 3 days' notice to come to this hearing, and we don't have those details on us.
Okay. Please take that on notice. But you would, of course, know for 2021?
As I said, we've had 3 days, and I don't have those details on me.
Okay, take that on notice, and also for 2020, please.
We will do.
Okay. How...
We know the number of matters we've had has been something less than 5, I believe, Miss Mann.
So we have provided the matters that have gone to the resources regulator, but we don't have the IRC.
Okay.
The details,
Thank you.
yeah.
How much money have you spent on external investigation reports into bullying or workplace culture?
Again, we'd need to take that on notice.
Okay. Okay, please take it on notice. I might see if Mr. Diaz...
Can I just ask
please.
a couple of clarifying
Please.
questions based on Mr. Primrose? You talked about the roles and you said you had 336 out of 370. So can you just clarify that obviously means you are not at UN standard? It's only when you hit 370 people in the role will you actually be at that UN standard?
Oh, that's a good question of clarification. I'll take that on notice.
Thank you.
Can I just, before I hand over to Mr. Diadam, there's just two other questions. Re the IDMP, what's the process of overturning decisions?
So it's a good question. Up until now, I have had confidence in that process, and I haven't had cause to look at overturning a decision of the IDMP. Some things that have come to light through this process have made me, as I said, I've asked for a review of that, and one of the points of review will be, the overturning process.
Has there been a process available to date on overturning?
So in my 11 months in the role, I haven't had cause or seen anything to cause me to overturn a decision. Ultimately, I have trusted that process and trusted the rigour of it. So I haven't overturned anything to
So
date.
it's a decision for you.
So the process currently is that the IDMP is the decision maker, and once they determine it should go to prosecution, it will then go to the prosecution section who will prepare for that. But I suppose, and this is something that I'm wanting to get some advice on, is if it did come to it and I saw an IDMP decision, could I, as head of Safe Work, overturn that? And my instinct tells me that I can, but I'm just wanting to get some advice on that.
Can I just clarify, and I'm not being funny about
Yep.
it, there's actually no written process at the moment that says...
Mr. Press seemed to indicate when I was questioning him that you couldn't overturn or you couldn't reopen that case from the IDMP. You
No,
said
so
it was statute, it was closed.
that specific one with Cooma, it ended up being statute barred the 1st of January this year. So that's what I was, that specific case. But if a case happened to be open now and we had reason to believe that there were errors or omissions or problems, then we could go back and interrogate. But that specific one had passed its.
So the only process to overturn it at the moment would be, Ms. Mann, for you to simply say, I've overturned it.
So the process is set up so that it's peer review and it's majority vote.
Yep.
As I said, I haven't in my 11 months had cause to intervene in any way. And in fact, the matters have gone from that panel to the prosecution unit. I think what I'm saying, Mr. Primrose, is I'm looking into that.
But there isn't a mechanism written down at the moment.
So there may well be, but I'm just trying to get some advice.
Okay, can you please take on notice then?
Yeah.
And again, I'm just trying to understand the process. If there is no mechanism, that's important to know. If there is a mechanism, how does it work and who makes the decision?
Yeah, no, it's a very good question and it's on my mind and we are working on that currently.
Yeah. You mentioned peer review. Who's on that?
So the IDMP is made up of the 7 Safe Work directors, of which Ms. McCall and Mr. Kelly are 2, and the other Safe Work directors. So I'm referring to those as peers.
Okay.
So the director with carriage of the matter, so the director within which the inspector reports to, or to who the inspector reports to, is the one presenting the case, and then the peer review I'm referring to is the review by the other 6 directors.
Okay, and there's been no decisions overturned then, in terms of your time?
So as Ms. McCall said, from time to time the recommendation made is not agreed to by the panel and they might make a different determination. But in terms of has the IDMP's decision been overturned, not in my 11 months. I haven't had cause to. I have trusted it's a good, rigorous process. It's good regulatory practice. I have trusted the process. But as I said, it's something that I've now opened up to look at a little bit more closely.
Okay. Yeah. Thank you. I might come back to that. Thank you, Mr. Diadam.
Can I, kind of picking up on that, can I clarify the I in IDMP? Is that independent or internal?
It's internal, so it's made up of the Safe Work directors, but probably to add to the conversation, where it's a tied vote, it goes to the executive director, which is Matt. If it's a fatality matter that we decide not to pursue, that has to go to the Executive Director of the Investigations area.
I think
So
you're
they're-
asking about the acronym, though, are you, Mr. Diadam? Whether the I stands for.
Yes, I was wondering if
It stands
guys
for
do
investigate,
independent
so-
or
investigation.
It actually stands for investigation, and that's one of the
neither
things.
independent nor internal.
Yeah, yeah, that's right. I thought it was independent, IDMP, but it's actually investigative, and that's one of the issues which I think confuses people is they think that it hasn't gone to investigation until it goes to that panel. Actually, in many cases, the inspector has done a very thorough investigation, and there've been multiple notices and compliance action taken before it gets to that panel. That panel is about determining whether it then meets, whether it then goes to prosecution. And I read out those factors that it considers. And some of it is reasonable prospects of success. I mean, we can't prosecute, and nor should we prosecute every single matter. So that panel is about determining which ones go to prosecution.
And does it have written terms of reference?
It does, yeah. So we've got some terms of reference. We've got the documents that they...
You provide those to the committee?
Absolutely, yeah, absolutely.
And what's the, how frequently does it meet?
Fortnightly.
Fortnightly.
And can I clarify, so I'm assuming there's minutes kept of the meetings?
That's correct.
Yes. And it has a chair?
Yes. Which is,
the
at the
chair?
moment, is the Regional Construction Director, which rotates.
But we are looking
Is
into
that you at the moment, Ms McCall?
No, I'm the Construction Metro Director, so it's my equivalent in the region.
I see. But the chair rotates between the directors, is that the...
That's correct.
Right, I see. Okay. Can I ask if on notice you could provide, I think Mr. Press indicated that some decisions are split decisions. Is it possible for the 355 to indicate the voting on each of those decisions? How many were unanimous? How many were split decisions?
Don't believe that's kept.
I think just to clarify, the chair has the final say. If there is 6 in attendance, 3 votes each, then the chair would have the deciding decision for the IDMP. I'm not aware of any matters that have been challenged by the IDMP. If they were challenged, then the Executive Director for the investigation stream would have a role to play. However, in my experience as a panel member of the IDMP, I'm not aware of any decisions that have been challenged.
And what's the time frame for a matter to be brought before the IDMP?
We aim for 30 days. However, that's essentially an aim. I know in my space, psychological matters take a lot longer to determine a recommendation for the IDMP panel. However, our general target is 30 days.
So it's a benchmark, it's not a requirement.
Correct. And the reason for that is to allow sufficient time for the investigation process using the statute of limitations of 2 years. We want to allow sufficient time for the full length of investigation to proceed and to seek legal advice before laying charges and proceeding with prosecution.
Okay. Ms McCall, I wanted to come back to the further answers to supplementary questions, particularly the answers rendered in relation to ability barges. So I note that there's a table in the answer in terms of requests for service notifications, and it has four particular incidents. And the first one, so this is a situation where an individual was killed as a result of a failure in relation to the operation of a crane. Someone was crushed to death. And there was a notification on the 6th of December that there was cranes being operated by crane drivers who weren't certified. Did that trigger an on-site visit?
So, again, I didn't investigate this matter, but looking back on the 6th of December was the first RFS. There was a notification raised. There was and then the workplace incident occurred on the 27th of January.
Yeah.
So, in relation, just going over the timeline.
So the information we have, Mr. Diadam, is that, yes, there was that request for service on the 6th of December. That actually came via the Speak Up app and included the allegations listed there. It was triaged as a Category 3, which means inspector response, but within 10 days. Then it was allocated to a safe work inspector, but the inspector response was delayed. It appears the response was delayed because of both COVID compliance and leave over that period. And so it was reallocated from one inspector to another inspector, and then that second inspector attended on the 8th of January. When the
8th of January.
Yes.
And so what was the outcome of that inspection on the 8th of January?
So the site was closed on that day, according to the inspector
I
notes.
say that's not listed in the answer. It says B, workplace on-site visits 27th of January, 28th of January, 3rd of February. Did you say someone visited on the 8th of January?
Yes, that's information, Diadam, that because we've done a further interrogation of the file that we've uncovered, so we can provide that information to you. So yes, there was a visit on the 8th of January.
And what was the regulatory action by the inspector when it went out?
It wasn't. The site was closed on that day, and so they were shut down. And so the notes of the inspector was they were going to come back before or on the date that they restarted work later in January.
Okay, so it seems that there was a notification, a request for service. It wasn't responded to in a timely way, and then someone died as a result of an issue that SafeWork was alerted to.
So
is that a fair assessment of what's happened?
This is one of the matters that is of real concern to me. So what I see here is our standards and processes not being followed by the inspectors. So yes, so the request for service on the 6th, it was triaged appropriately. So it came in on the Speak Up app at 6:37 p.m. It was triaged appropriately on the 7th of December, and at 8:19 a.m. It was triaged for inspector response. But there was then that failure, as I said. The Category 3 requires that response within 10 days. And that inspector didn't go out there within the timeframes. It was then reallocated to a different inspector, and that inspector attended the site when it was shut. So for me, this is one that I really want to look into further, because a lot of our processes don't appear to have been followed in this matter by the inspectors.
And it had catastrophic consequences, didn't it?
Well, there was a fatality. Yes, that's correct, on the 27th of January, which is obviously tragic.
Yeah. And I think, Mr. Diadam, some of your questions earlier, though, I think the change in approach that we've got to secure is that it can't be just because of SafeWorks' presence on a site that we have behavioural change. We've got to get that behavioural change deeper. We're never going to be on every construction site or at every business day in, day out. We're always going to have, constrained resources and don't have to pick and choose where we attend. So we've got to make sure that regardless of whether we're there or not, that safety culture and the processes that you were talking about are ingrained. And that's our challenge.
Doesn't that mean the PCBUs have to believe that if they break the law, the work health and safety laws, that it will occasion serious consequences for them? Isn't that the object?
No, that's part of it. They also have to be thinking about this is investing, in the staff and the safety of their staff. They need to be thinking that, these are these are husbands and wives and family members, and they absolutely should be making sure that they go home safely each and every day. The prosecution part is too late. Back to your point about prevention, this needs to be invested in the second that you open up the gate.
Not prosecution, deterrence, Mr. Press. They have to be deterred. Do they not?
It's about all parts, Mr. Chairman. I don't think you can say just about one part or another. All of the different parts have got to come together.
So on the 14th of February at Ability Barges, there was a further request for service indicating that, again, crane operators were operating without licences. This is after the fatality, after Safe Work have been on site 2 days in a row. How is that possible?
Mr. Adam, I can't explain what's happened. Or we can say, like Ms. Mann has said, that we want Mr. McDougall to look into this to see what changes we can make as an organisation to improve and to reduce the chance of these things happening in the future.
However, can I add that this matter is under full investigation, meaning with the intent to prosecute. It's fairly advanced, and all the history is included within that investigation.
And I should say, Mr. Diadam, we've explored this morning a number of matters which I would agree have not been often dealt with in accordance with our processes and procedures, and definitely we could have done better. I would say, though, that we've delved into a few matters like that, but there are also thousands upon thousands of matters that are not like this and that are dealt with in an extremely professional way by an extremely committed workforce who are genuinely doing their best to bring workers home safely and to change culture and to do all of those things that everyone around the table wants to see. So I just do want to acknowledge that these are case studies which absolutely on any view we can do better and we want to do better, but I just didn't want to take away from the important and good work that the team's doing that hasn't been raised this morning. It's a hard job, and it's not an easy job.
We've asked about whether the Safe Work has adequate resources, and the answers returned from the leadership of the department has been, yes, we've got enough resources to do the job. I look at the statistics that are returned in the answers, supplementary questions around requests for services, and then those that occasion inspections. And the numbers aren't particularly good. We've got 21, 22, 31,084 notifiable incidents with only 1,151 inspections. That doesn't suggest that you've got enough resources to actually meet the challenge that you face. Do you agree, Ms. Mann?
So, Mr. Diadam, I would never say no to more resources and funding from government for more inspectors. I would, of course, I would never say no to that. But as Mr. Press mentioned, we are never going to be able to get out to every single work site. There are 4 million or so workers around New South Wales. We can't possibly have full coverage all of the time, every time. And so I think, as we've discussed this morning, it is not just about on-site visits, although that is an important part, but it's about really changing that safety culture and really making PCBUs understand that this is important and this is a matter often of life and death and that they need to do better. So it's resources is just having an extra 10 inspectors isn't going to solve the problems. We're using robust processes and procedures. We have the triaging policy, which is best practice and is used around the country. So we are following, for the most part, those procedures. So it's not just a matter of resources. It's about those other things too.
So can I ask about that? The decision to dispatch an inspector to a site in response to a request for service. That's just made by an algorithm?
No, it's not. It's not made by an algorithm. I don't know whether you wanted to talk to.
Yeah, so inspectors triage the matters as they come in. As you said, we get around 20,000 a year. That's made up of incidents and requests for services. There's 6 categories, which is a national framework in how we triage. We get that information by people either calling up or via the Speak Up app. And again, they're triaged from 1 to 6, being category 1, it's within 24 hours and involves an inspector visit. Category 2, within 72 hours and involves an inspector visit. When you get to category 3, that is 10 days, but it can be either a visit, desktop, over the phone, depending on what the situation could just be that they're requiring information. Category 4 is where we do start getting into the administrative responses. Category 5 is where there's insufficient information, and category 6 is where it's not under statute. So that's exactly the same across the country. And in terms of that guides the work. So sometimes though, the way that the person has notified and it's categorised, sometimes we can scale that up or scale that down depending on what information was provided.
May I, in the last few seconds, Mr. Diadam, just ask one
hand over
quick,
to
and please take it on notice if I can. In terms of the IDMP overturning decisions, can you please tell us on notice how many of those decisions were overturned in 2021 and 2022 to date, and how many of those involve deaths or serious injury?
So I think Ms McCall has given you the data already in terms of the numbers overturned, but or not supported for original decision. But I think we can delve into what they related to. Absolutely.
Okay.
Yeah.
Mr. Primrose, I can also add just in relation to fatalities, if the IDMP opposes the inspector's decision or recommendation for a fatality matter, it does go to the Deputy Secretary for the IDMP. So I'm not aware of any in recent times, but that is the process.
Okay, thank you.
Now, before I hand to the government for their question, just one clarifying question quickly on the IDMP. You said that there's a chair and it rotates. If the chair has a case coming before the panel, do they then have to step down so they're not put in a position where they have to make the line ball?
So they don't present. They present their own case, but they're not permitted to vote, and someone takes the chair just for that matter.
Okay, thank you. I now turn to the government, Mr. Martin.
Thank you, Chair. Look, I don't have any specific questions, but if there's anything raised this morning that you'd like to revisit, clean up, please take the opportunity.
Thank you.
Yes, ma'am.
So, thank you for the question. As I said, I've been here for 11 months now, and on the whole, people are doing a wonderful job, and we should be really proud of our inspectors and our safe work team. They're doing a fantastic job. Is there room for improvement? Absolutely, and that's obviously why we have Mr. McDougall and the Auditor General carrying out those reviews. So I just wanted to thank the committee for their time this morning, and I just wanted to thank the safe work inspectors and the rest of the team back. I know sometimes, they take these things quite hard because they are doing their best, and I just want to call out and say I know that, and we all know that, so we're just going to try and be a bit better. Thanks.
Thank you.
Okay, well, thank you. That concludes our supplementary hearing this morning. You did elect to take a few questions on notice, so the Secretary will be in touch and you'll have 21 days to get back to us. But once again, thank you for coming in again.
Yes, thank you.
Appreciate the short notice as well, so thank you for your time.
Thank you.
Thank you.
Thanks.